On December 2nd, 2024, former law enforcement officer Jeffrey Smith opened fire on another driver during a road rage incident in San Antonio, Texas.
On December 2nd, 2024, former law enforcement officer Jeffrey Smith became the center of a serious road conflict in San Antonio, Texas, after he fired at another driver during a heated encounter. Reports stated that he used a firearm fitted with a sound-suppressing device and also displayed a police badge from his previous career, which made the situation even more alarming. On February 20th, 2025, prosecutors officially filed charges against Mr. Smith in the 187th District Court in Bexar County. He faced 2 felony accusations, including assault involving a deadly weapon and pretending to act as a public official. To defend himself, Mr. Smith hired attorneys Tilden Schaefer and Kurt Granzi, who later worked with prosecutors to reach a negotiated agreement. The proposed resolution involved deferred adjudication, which is a legal option available under Article 42 and 101 of the Texas Code of Criminal Procedure. Under this process, a judge accepts a guilty plea but delays entering a formal finding of guilt while placing the defendant under strict community supervision with court-ordered rules that must be followed. If every condition is completed successfully, the case can be dismissed without a criminal conviction, which gives the defendant a chance to avoid that final outcome. However, the court continues to hold full authority during the supervision period and can enter a finding of guilt and deliver any sentence allowed by law if those conditions are not followed. On November 12th, 2025, Mr. Smith formally entered his plea before Judge Stephanie Boyd, and the courtroom then moved forward into the sentencing stage as the next major step in the case.
All right, first, why should I follow this plea bargain agreement?
Judge, I think this is a situation where my client greatly regrets what he did. It's a situation that got out of control. And I think based on his background and age, it's one of those, we should have made much wiser decisions. He doesn't have a violent background. And I do know, and I think the court can tell from how he's answering questions, there's quite a bit of regret in this entire affair, Your Honor.
All right, so why did it come to this?
Your Honor, it was just a messed up situation that night. I wish I could have made a different decision. You know, my son was in the car with me. I was worried about his safety 100%. And I'm a minute that hasn't gone by since this happened that I wish I could have made a better decision that night.
Okay, I understand what you're saying, but I still don't understand how an argument on the road comes to a pulling of a weapon. I just don't understand that. And they're asking for a driver safety course. They're asking for a gun safety course. They're asking that you forfeit your Horseshoe Bay badge credentials. And they're saying that you flashed a badge and that you were no longer employed with them. So I'm just trying to figure out what conditions would be appropriate for you. This is why I asked these questions, because there's a lot listed.
Used the old time to diffuse the situation. I thought it would help. That was it. There was no other reason behind it.
Why did you still have the badge?
It was given to me by my chief of police at the time as a memento, because that was my first job there. Before I went to Border Patrol.
So where do you work now?
I've left law. I left Border Patrol in 2016. I went back to construction. I'm a home inspector for new homes. Till this happened, I was planning on going back to actually apply for ICE. That's null and void.
But here it says that you pulled out a handgun with a silencer attached to it and opened fire. Am I reading that incorrectly?
No, so Judge, he has a suppressor, and so his parents live near Kerrville.
Okay.
That's what the mother and father, they had gone out to her birthday celebration that night. He was going home with his son, and they have it's in a rural area, so they actually have kind of a setup where they do target practice. The suppressor has more to do with not making loud bangs. That's why and it's legally owned. He's got the stamp for it. I have it in my file back, trial file. It's not illegally possessed. Otherwise, I guess the feds would be involved in this case, Your Honor. That's why I had the silencer. I can tell you that there was a perception on my client's part that the kid was tailgating. Then there was a brake check, which you can see from the statement in the police reports. And then the kid comes around really close, rolls down his window, honks at him, yells, starts cussing, and it kind of goes from there, it goes kind of south. I think my client thought he could handle the situation. He thought he would diffuse it with the badge. That didn't work. And then at the moment when this all happened, apparently the young man had a phone in his hand. This was at night, and he made a gesture kind of with his hand to the side, which at that moment in time, my client, who was already kind of freaked out, thought it was a gun. And this was an apparent danger case, Your Honor. Police didn't find a gun in the kid's car, but that's what we saw. We actually, in the subpoenas, dug up extraneous acts where a kid had got in trouble at school for posting shots on social media with him with guns. And he's holding it the same way he was holding the phone. When he's talking to the police officers, he's holding it, and he's pointing like this. So that's the gesture my client saw in that moment. He made a mistake. We've spent a lot of time on this. The state has spent a lot of time. They showed us a new witness who was the girlfriend of the young man in the car at the time that nobody had ever found. We'd always wondered, why weren't they looking for the girlfriend? We couldn't find her. We didn't know her name. Ms. Alban did a great job preparing for trial. And that's kind of why we're here today, Judge. I think both sides have kind of met in the middle. Again, my client doesn't have a violent background. It's just, thank God that he didn't hit the kid. So that's why we're here. So,
Oh, is there something else?
Well, I mean, I'm not sure it's clear. The gun was in the car because of going out target practicing, but he had gone and met his family for dinner, and he was going home, and they were in the back seat of the car, in a bag. You know, it wasn't as if he routinely carries a gun.
he had been target practicing at his parents' house prior to dinner. He actually had a concealed carry permit, which he's since had to relinquish. The state revoked because of this.
Is there anything else?
No, Your Honor.
Anything else from the state?
You have a restitution amount, but on the judgment,
Yes.
it's $2,463.82.
I'm sorry.
Okay.
Just 1 second. If you could repeat that.
$2,463.82.
So is there any disagreement on that restitution amount?
No, I think that was part of the discovery. We actually had the receipt from the repair shop, Your Honor.
And where will you have that restitution amount?
Judge, I think it's going to take a couple of months if the court would entertain that. He started this job about June, maybe, and so there's been some lag time. And I mean, he is the independent contractor, so lag time in taking the jobs and getting paid.
All right, just 1 second. Excuse me. Everybody on this side, y'all need to move because probation can't see and they can't hear what's going on. All right, so when do you think it will be? Oh, and state your excuse. When do you think he will have that?
I would say a minimum 2 months.
Yeah, 60 days.
All right. And that's 60 days from today?
Judge Boyd then turns her attention to the payment that Jeffrey Smith must provide to the affected driver. This court-ordered payment is meant to cover financial losses that can be directly connected to the incident and is based on actual expenses rather than estimates. Texas courts have explained that this type of payment has two important purposes. It helps the affected person recover from the damage, while also encouraging the defendant to accept responsibility for the actions that led to the case. Under Article 42.037 of the Texas Code of Criminal Procedure, a judge has the authority to require payment for property damage that resulted from an offense. In this case, the damage happened when Mr. Smith discharged his firearm and the other driver's vehicle needed repairs. The final amount approved by the court was calculated using a repair shop invoice that showed the cost of fixing the vehicle. Because of that record, the payment will go toward covering those repair expenses and helping restore the vehicle to its previous condition while completing another important part of the court process.
All right. This is what the court is going to do. The court, and I'm going to tell you, I was considering sending you to jail as a condition, but the state is saying that the complainant is in agreement to this being your sentence. So you can thank the complainant for that. Because sometimes I feel as though people need to have a chance to be alone in their thoughts at the jail to consider everything that is what they've done. And it appears that you've taken that into consideration. And it appears that on this night, Everything that could go wrong did go wrong. But don't brake check people. People don't like to be brake checked. That's just my experience from driving.
Judge Boyd carefully explains to Mr. Smith that her decision to approve deferred adjudication without requiring time behind bars was strongly influenced by the fact that the other driver supported the negotiated agreement. She points out that this level of agreement played an important role when the court reviewed the final outcome of the case. Texas law gives crime victims several important rights, including receiving updates about the case, and having their victim impact statement reviewed before a plea agreement is accepted by the court. Even so, the law does not require a victim to approve every detail of a negotiated resolution before it can move forward. The final decision remains with the judge, who has the authority to either accept or reject the agreement after considering all of the facts and circumstances. In many cases, judges also take the views of the affected person into careful consideration before reaching a conclusion. In this situation, Judge Boyd determined that the proposed agreement was appropriate because the defendant, the prosecution, and the other driver all supported the same resolution, which allowed the case to proceed without a custodial sentence.
New home inspections.
All right. He can do regular random UAs, or either you can do the patch. The patch costs more, but with the patch, it gives you more freedom because probation will put it on and probation will take it off. Patch costs more though. So you can either do regular random UAs or the patch. Proof of employment within 45 days. There's to be no employment as a home health care provider with minors. 120 hours of community service restitution. I'm going to require parenting classes. Once you complete that, the community service hours will be deemed satisfied. MRT, the anger management course. You're to forfeit the weapon, and you're to forfeit your horseshoe bay badge credentials. There's to be no firearm possession. There's to be restitution in the amount of $2,463.82 to Joseph Perez, and that's to be paid in full within 60 days. There's to be no contact with Joseph Perez. There's to be no employment with law enforcement or any type of security. There's to be field visits one time per month for 6 months. Are you here in Bexar County?
Yes, ma'am.
All right. Probation. Is there anything else?
No.
All right. And I'm sorry, there's a $1,500 fine that will be probated.
Judge Boyd officially places Mr. Smith on 5 years of deferred adjudication and carefully reviews every condition that he must follow during his period of community supervision. He is required to report to probation on a regular schedule, provide proof of employment within 45 days, complete parenting and anger management courses, allow monthly field visits, give up his firearm along with any former law enforcement credentials, follow employment limitations, pay $2,463.82 to cover the approved vehicle repair costs, and avoid all contact with the other driver. The judge also explains that he must either take unannounced substance screening tests whenever directed by community supervision officers or wear a monitoring patch that tracks alcohol or controlled substance use over a set period of time. These requirements are part of the supervision process and are intended to make sure every court-ordered rule is followed throughout the term. Texas law gives judges broad authority to create reasonable supervision conditions for defendants who receive deferred adjudication as long as those conditions support public safety, help the affected person encourage accountability, and promote positive rehabilitation. Because of that legal authority, Judge Boyd was fully permitted to include each of these requirements as part of Mr. Smith's supervision plan and warned that failing to follow them could lead to more serious legal consequences in the future.
Is there anything else that you need from the court?
Yeah, Judge, in regard to employment, if some of the jobs are out of county, I know some are in contiguous counties, but if they're further, can he get permission to do that if he shows probation where he's going?
Yes.
Okay.
Probation, he's allowed to work throughout Bexar County and other counties, but you'll need to provide notification to probation that you're going to be working out of county. Working in county, that's fine. But if you're going out of county, you need to let them know. All right. Is there anything else?
And I just, actually part of the plea bargain was actually to not only just waive, but to actually dismiss the set count too. I don't know if that was clear. You did do it, You waived it, but that is part of the inducement for the plea, and it was to be.
Oh, I've already said that it's been waived. It's on the record.
No, I understand that, but I'm just being hyper-technical.
No. I understand what you're saying, but I put on the record that
Yes.
it was waived and you all had no objections to it being waived.
Correct,
So
correct.
it will not come back.
Okay.
It's not allowed to come back.
There you go.
'Cause-
That's what I
All
want.
right.
All right,
Thank you.
sorry.
No problem.
All
Did you, and I'm sorry, there's an affirmative finding of deadly weapon. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
Because it's a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand? All right, we can go off the record. In this court, communication with probation is key. If there's an issue, you need to let them know about it. If you feel they're not addressing it, you can always come back and address it to court. But whatever you do not disappear on probation. That's not a good look. You understand? All right, good luck to you. Thank you.
Thank you.
Mr. Smith received deferred adjudication for the aggravated assault case, while the charge related to presenting himself as a police officer was dismissed as part of the negotiated resolution. At the time this report was prepared, there was no public information showing that he had failed to follow any of the conditions placed on his community supervision. This case offers a clear example of how deferred adjudication works in Texas and shows the important role a judge plays when deciding whether this type of outcome is appropriate. Judge Boyd accepted Mr. Smith's guilty plea, but delayed entering a formal finding of guilt while placing him under detailed court-ordered supervision for 5 years. Those conditions were designed to promote public safety, address the financial loss experienced by the other driver, and encourage responsible conduct moving forward. Judge Boyd also explained that although Texas law did not require the other driver to approve the agreement, that support carried significant weight when she decided to accept the negotiated resolution without ordering time in custody. At the same time, she required documented repayment for the vehicle repairs to make sure the financial damage was acknowledged and addressed through a verified amount. In the end, Mr. Smith avoided immediate incarceration, but remained subject to strict supervision with serious legal consequences if he failed to follow the court-ordered rules. The outcome shows that deferred adjudication is not a free pass, but a carefully monitored opportunity that depends on continued compliance with every condition set by the court. In this case, the judge determined that the agreement was appropriate because the person most directly affected accepted the proposed resolution along with the other parties involved. If there is another courtroom case or legal proceeding you would like us to cover, share it in the comment below.